Selamat sore. Good afternoon.
Selamat sore, Ibu Tiana.
Ya, selamat sore, Bu Rosa. Salam kenal, am I audible, Ibu?
Sorry, Ibu, boleh diulang?
Oh ya, am I audible? Kedengaran suaranya?
Bagus.
Oke, nice.
Hello, how are you? Can
Hello.
you hear me?
Yes,
Hi, how are
very
you?
good. Hi, I'm good. How are you?
I'm good. I'm good. Yourself?
Good, very good. And good morning to you.
Thank you so much. And good afternoon to you. Yeah, maybe evening time approaching fast in your region, I'm assuming. Yeah.
Yes.
And what's your,
Sorry, can you repeat that?
are you Rosa?
Yes. Oh, yes, yes, yes. I'm Rosa. Nice to meet you.
Great to meet you, Rosa. Great. Good morning after you to all. Hi, good morning. Okay, so how many will attend, do you think? What's the
Uh,
last the latest?
sorry, participant is it's around 220-ish. So we hopefully all of them join today.
Yes, fingers crossed. Great, fingers
But
crossed.
no worries, we already sent all the Zoom details and everything to each of them. So we'll just wait and see.
Okay. Can I take my time or do you need me? I'm just, is there anything we need to do?
No, no, no. So right now we just wait, and then um, so the rundown will be 4 o'clock. We will start, but before 4 o'clock, around like 5 minutes before 4 o'clock, we will play like the opening video. The
Okay,
opening video consists of sorry, it's highlighting your the speakers and moderator picture, profile, etc. So
yeah, good.
it will run for like 4 minutes ish, and
Okay.
then after that we'll start 4 o'clock
Morning.
opening by
Hi.
moderator, Mr. Andi.
Okay, sounds great. Okay, so I basically have 5 minutes then, which is nice.
Yes, yes, yes.
I shall be back. Okay,
Okay,
bye.
thank you.
Mbak Rosa,
Pak siapa ini?
Anggi,
Oh, Pak Anggi ya Pak.
eh,
Yang
would
tentang
you,
yes,
ah,
Ibu ini sudah Pak Fitri at Apelo Solution kan ya? Sudah saya masukkan kok Pak. Eh, di di sudah saya masukkan emailnya untuk jadi panelis. Apa belum terima?
sudah, cuman di sini masuknya attendees.
Oh gitu. Oke, coba saya ulang ya Pak ya. Bentar ya.
Ya, thank you.
Pak Anggi nggak apa-apa dimasuk aja kalau sebagai attendee nanti saya naikkan menjadi panelis.
Alright, thank you, Mbak Rosa.
Halo Ibu Fitri, good morning. I hope you feel better today. It's nice to meet you as well, Dr. Melis Oster. It's an honor.
Hello, everyone. It's great to be here, and today I'll be talking about one of the most strategically important maritime choke points in the world, the Strait of Hormuz. So for decades, this narrow passage has been the artery of global energy trade. As we all know, roughly 1/5 of the global oil supply, alongside significant LNG and fertilizer flows, routinely passes through this corridor. Although there are alternative infrastructure project options there in the region, such as pipelines, these are only partial substitutes. So past disruptions we have seen in the region have already triggered force majeure declarations and demonstrated the fragility of global energy supply chains. Yet, in recent periods of geopolitical tension, the strait is now raising deeper legal and commercial questions. So in addressing all these situations, I'll consider a number of interlinked legal issues with you. So first, I will be talking about how such situations are tackled in legal terms, with particular reference to two important tools that we have got, so two important contractual tools that we have got that we frequently see in shipping contracts, international sale contracts. So these are namely frustration and force majeure. And I shall also be discussing how and the high threshold that we see that is required for such contracts to be discharged in circumstances of war, disruption, or effective interference with maritime routes. And then I shall discuss how risk is allocated, particularly in voyage and time charter parties, with particular focus on the operation of standard form war risk clauses. So starting first with frustration and force majeure, I have checked the list of audience. I think many of the participants are from Indonesia. If that's correct, maybe you can just write in the chat box. I'm assuming that in your legal system, it's civil law. Is that right? Is it civil law or common law mainly?
I think that's correct. First of all, I would like to bring Pak Andi, Mr. Andi, as the moderator. Pak
Okay.
Andi, please welcome.
Right.
Thank you very much. Hi, Melis, how are you?
All
Also, Diana.
well yourself. So
Thank you
is
so
it
much
common law?
for the short opening. Let us restart if I may. Sorry, it was a bit tricky for me because of this webinar system. So I missed that. I supposed to speak actually short after the video, but then I I missed
Whenever
a few
there's
seconds.
a gap, I just felt the need to talk. So
Right. So, all right, thank you very much. I think you already, Melis, thank you very much for that opening. I would like now to properly introduce everybody to the audience. Now we have 40 plus. I think we're expecting more, right, to come to the event today. So if we talk about the shipping and trade, maybe in a general observation, I usually say this, Melis, to my students: whatever you have now, say it, your computer, your glasses, your watch, your phone, that might reach you through the ocean instead of other ways, right? So meaning that ocean, which is 70% of the Earth's surface, is actually very important. And that is now becomes very important why we talk about shipping and trade contracts. And now we have with us Melis Osdal. Thank you very much once again for coming. We also have Ibu Fitri here, but for some reason, we are really sorry that Ibu Fitri will not be able to participate as we wanted. Sorry for that, Ibu Fitri. I know that you were ill, but we wish you a speedy recovery. But to accompany Ibu Fitri, we also have Ibu Tiana Sigi Pertiwi, a lawyer that would like to also say more later. So without further ado, because you, Melis, already started, which I really appreciate, now you can continue, and then I will like to transition to Tiana. Please, the time is yours.
Thank you very much, Andy. So I guess all the background I've already given. So I'm now moving on to the operation of frustration and force majeure.
Right.
I have seen a reply here saying Indonesia is a common law jurisdiction. So proceeding on that, I'm assuming that you probably have got a similar doctrine of frustration that is applicable to contracts governed by English law. So what we therefore see when we have frustration in operation is its application is quite limited. And that is why in most commercial contracts, we do also see force majeure clauses. We don't have a doctrine of force majeure as such. In civil law jurisdiction, there is one, and that does apply because they have got their code, civil obligation code, that will require application of force force majeure doctrine to any commercial contract, whereas we don't have such a mechanism in place. We have doctrine of frustration, which has got really narrow application. And in my speech, I will be talking about the threshold, particularly that threshold for contracts to be discharged, for contracts to be frustrated, what the courts want to see, obviously considering the current situation that we are in the Strait of Hormuz and the closure, the effective closure of that, whether it can effectively frustrate contracts we have that are governed by English law. These doctrines are both force majeure and frustration doctrines that are quite important, significant, as I'm sure you know, because in defined circumstances, they excuse non-performance without giving rise to any liability for breaches. And I'm sure you all know frustration actually does require a supervening event, so beyond parties' control without their fault. And it really should ideally render performance impossible, so that's the gold standard, we would say, or alternatively, rendering the performance of the contract radically. And the important thing there is radically different. So just because the performance has now become onerous, burdensome to parties is not sufficient to frustrate the contract. So looking at the situation that we're in, obviously the situation is burdensome economically to every party involved in the situation, but just because you're economically in a worse position is not a sufficient ground to say the contract is frustrated. So also, if you think about all the ships there, we don't have many ships that have actually been damaged. Most of them are just lying idle at the moment, waiting for the tension to ease. So that, in essence, tells us that we can't potentially speak of physical impossibility of contractual performance. We're probably steering more towards delays, and whether these could radically alter contractual performance as the time passes by, whether the delay is significant, such as to frustrate the entire contractual advantage that the parties wanted to attain when they entered into contract. So that's what we're actually looking at right now. And that is why we see now many commercial parties going to happen and then decide whether, because if the contract is not frustrated and if you pretend that it did frustrate, then you obviously would put yourself in repudiatory breach, and that will mean you will be liable for substantial damages, and obviously no party would like to be in that kind of position. So it's quite important, therefore, to at least have some certainty as to whether frustration is actually a viable argument to make in the circumstances. We know from English case laws that delay may well frustrate contracts. So we have got some important cases like NEMA, where also, in that case, the House of Lords also recognized that in case of conflict, it's impossible to predict when the stability will return. And that uncertainty itself can make frustration sometimes difficult to establish, but obviously it is not impossible to establish frustration just because you have this uncertainty that we usually see in situations like this. But NEMA also itself acknowledges that you may well have some frustrating events that are not necessarily one-off, which is the situation we're in, affecting not just one party, two parties to a particular contract, but you may well have some events of a general character that may affect similar transactions between many persons engaged in the same kind of commercial activity, which is what we currently have. And in that case, the reference was made to things like closure of Suez Canal, the United States soybean meal embargo, the war between Iraq and Iran. So we have seen similar cases in the past, especially in that region as well. And we have also seen cases where the courts decided that the significant delays may well frustrate contracts. But the crucial thing obviously here is whether a contract is frustrated or not is context-specific inquiry. It's a fact-specific inquiry. There are no hard and fast answers. We don't have anything that we can actually apply to any type of contract at hand that are currently affected by the situation. So the context is therefore critical. Where you have got cargoes that are highly time sensitive, let's say you have got an LNG supply contract and the agreement there is to supply this into energy dependent markets, let's say South Korea, etc., where you have got significant proportion of supply that may well depend on timely delivery. So the ability to wait and see may not be commercially realistic in those circumstances. And the delays that parties are currently encountering at this point in time, that can render the contractual performance radically different. So the crucial question is therefore the nature of the contract that is at hand, whether delivery, supply of something is time sensitive, the effect of the delay that will have on the contractual performance. So all those matters are important for the purpose of deciding whether the contract at hand can be frustrated or not. Another interesting aspect here is foreseeability, because we now need to think of two ways. This is an ongoing situation. Some contracts were concluded before the tension. People are still entering into contracts during the tension, right? And how we're going to place foreseeability into our analysis for contract frustration. It's an important factor. So if you look at any English case law, you will see some reference to foreseeability. Usually, while an unforeseen event will not necessarily lead to frustration of contract, in most cases it may. The event is unforeseeable. That could be something that could lead to and contribute to the contract being frustrated. But sometimes what you actually see is you have a foreseen event, and usually this is considered to exclude the operation of the doctrine. So if you have a foreseen event, the prima facie rule is the contract can't be frustrated, but still the courts do say, well, in exceptional cases, this can be excluded by evidence of contrary intention. So if you have an unforeseeable event, quite likely you may well be in a position to argue frustration. Obviously, other factors need to be considered as well, together with unforeseeability. If you have an event that is already foreseeable, it will be difficult for you to argue established frustration. It's not impossible. I mean, even in cases in NEMA, there was a frustration case. That was a frustration case. And the frustrating event was strike. And strikes are not unforeseeable events. They do happen. So what we therefore see is if the event is a foreseen event, the threshold for frustration gets a bit higher, but it's not impossible to argue frustration, establish it successfully, but it's not going to be an easy task. That is obviously what the courts do tell us. Now, to reinforce all this analysis on frustration, it's also important to refer to some important English cases, such as the Kyla. So there, the quite important thing that the court said was, frustration is no longer a rigid doctrine. It's no longer, it's not something that we are willing to categorically apply to situations where we see a supervening event. It is becoming more and more contractual and contextual. And Kyla is one of the key cases on that. The facts are not similar to what we're currently experiencing in the Strait of Hormuz, but it really does give us a very important reminder that if the contract itself makes some provisions for the event or contingency which has occurred, in those circumstances, the courts may well say the contract is not frustrated. Why? Because parties thought about that possibility, the event, the contingency, and they have put in place their contractual provision. And if that is the case, the court will say no frustration, because you have got in hand your contract provisions about this risk allocation. So you have this contingency, you thought about it, you provided a provision in your contract. It has now happened. I'm not going to say the contract is frustrated because you have a provision in place to cover those situations. So this is very important. That is why we can now no longer say, and we shouldn't be saying, oh, we have a supervening event beyond parties' control. Now the courts also want to see what you have put in your contract, what you have in place. Have you considered that contingency? Have you got any provision that can actually solve the issue about the risk allocation in relation to that particular contingency in question? So very, very important things that we actually see that, with the court decisions, clarifying these important elements that really help us understand how doctrine of frustration operates in modern times. Now, moving on to force majeure, as I have already said, we don't have a doctrine of force majeure. This is not something that is applied by law. It has got its contractual source, and you need to really have a specific, clear contractual mechanism in place for a force majeure event, for a force majeure clause to operate. And it's really important if the parties want to excuse themselves from performance, it's really important for them to bring themselves neatly within the corners of the force majeure clause. We had a very recent, very interesting Supreme Court case, so Mer shipping, which actually told us something quite important, which is also very relevant to the situation that we're in. Usually we see in force majeure clauses provisions in relation to reasonable endeavors. So if you have got, let's say, some barriers, some harshness, some issues in relation to performance, you need to use your reasonable endeavors to try to comply with your obligation somehow in an alternative way. Now, the Supreme Court has said that you cannot obviously have a situation, let's say, where you have a party that, let's say, causes a force majeure event. They cannot actually ask the other party to use their reasonable endeavors and try to perform the contract with some non-contractual alternative methods. So what is a non-contractual alternative method for a contractual performance? What would be treated as a non-contractual performance? What would be considered as contractual performance? That will obviously depend on the contract at hand. But it's obviously quite an important reminder for us when we apply force majeure clauses. Now, looking at the situation we're in, looking at these trade reformers, so the legal threshold, what we see is it's obviously up to the parties to decide whether they should argue frustration or not. But as I have said and highlighted earlier, this is really a question of context and the contract that you have got. So you need to factor into a lot of things because in most cases you'll be arguing delay, and delay should be significant to frustrate the entire adventure. This is what you're trying to argue. It may not well be easy to argue. And you may also have got some issues in relation to your contract, because you can have some provisions specifically covering such contingencies that will also make it, in most cases, impossible for you to argue frustration. So force majeure clauses are fact specific, but we know that courts do not write the contract for parties. So doctrines of frustration, force majeure, they are not actually there. They're not mechanisms for rebalancing commercial bargains in response to geographical disruption, such as the one we have got. These are actually carefully constrained legal tools that operate within strict contractual boundaries. So in most cases, a lot will be decided and determined with reference to the contract clauses that parties do have. So the other issue that I want to discuss is the charter party risk structures. Because we increasingly see in charter parties, in void charters, in time charters, standard form raw risk clauses. So the two important ones are promulgated by BIMCO. So I'm assuming you do know. Yes, you can just write in the chat box. It will be nice to have some interaction. So if you have heard of it or not. So those are quite important ones. They are widely in use. So we have got two recent versions of So they are voiver, so void charters, and convert time for time to 2025. In the past, we had 2013 forms, so they're earlier versions. The recent versions bring a lot of clarification about a wide range of things. So what should be understood by war, how the master judgment should be assessed, etc. The allocation of the excess costs and things like that. But if you look at the spirit and the essence and the main purpose of these clauses, they haven't changed. So the real meaning, the real functioning of these clauses have not changed, but more clarification has been brought with these new versions. It's still possible to see the old versions being used in charter parties. BIMCO has a very, very useful website really explaining how the new versions operate, just to explain the clarifications put on there. So it might be an interesting and useful read for anyone who really needs to look into it for legal advice or other sorts of things. So convert time. So this is obviously one of the key clauses for time charters, giving the owners and masters the liberty to refuse charterers' orders. So giving broad liberty to master and owners. So the vessel, and it literally says the vessel is not obliged to proceed to or through any area where in the reasonable judgment of the master and owners, the vessel cargo or crew may be exposed to a war risk. So quite relevant to the situation that we're in. And this obviously applies, and that's quite important, whether or not the risk existed at the time of contracting or whether it arises later. So convert time clause is quite an important one and still has got this application. So let's say you have entered into a time charter party after the beginning of this tension, still your convert time clause will be applicable in theory, because it basically says that the right discretion to refuse to obey charterers' instructions, that right exists irrespective of the time of contracting. So whether after the war or before the war. So which is good news. One of the crucial things is how this judgment is actually applied in practice. So what is the master or the owner should look into? So how they're expected to exercise their judgment. So what should be the level of the risk that they should see for the purpose of being able to say we are refusing to comply with the order. We don't have a recent case that actually deals with reference to the newest version of the convert time clause. But we do have an English decision, which is a Triton law. So although this case was concerned the convert time 1993 wording, the previous wording, it can still be applied to the new wording because, as I said, there are no dramatic, massive changes between the two. And it really clearly says if there is a bare possibility of risk, it is not sufficient for the master or the owner to refuse to comply with the charter's orders. The assessment of risk, the court says, must really be grounded in evidence. We don't expect a very high threshold here, like 50-50 probability. But really, you need to have a situation where the risk actually can be shown and substantiated with evidence. So it shouldn't just be a bare possibility. So you're basically looking at between those two things, two extremes. And so speculations, probabilities, they're not going to be sufficient. You really require a genuine evidence-based assessment of a real or somewhat credible risk to be able to refuse to comply with the charter's orders. Another important thing, so there are always ifs and buts here. Another recent Supreme Court case, the Polar, which is a very, very useful case, particularly when dealing with situations like this. It says a number of things, but the most important thing here is, yes, you have your convert time. You may well say it's great. And it clearly says, well, it doesn't matter whether the risk exists before or after. Fantastic. But this Supreme Court decision clearly says that there's got to be a qualitative increase in the risk. If you have already entered into a contract, a time charter, at the time you, let's say, have got this warlike situation, in the Gulf, in the Straits, and if you're just relying on your convoy time, just beware, because for you now to be able to refuse the charter's orders, you need to show that there is a qualitative increase in the risk, because at the time you entered the contract, both parties were aware of the risk. So that's obviously the crucial thing. So now to be able to refuse to comply with the charter's orders, you need to show not just the risk, which already existed, but increase of that risk that the parties were already aware of. So that's very, very important. And there also the court again looked into the contractual context and said, well, in relation to the situation in relation to the Gulf of Aden, you have got a contractual provision covering that contingency, about the war risk insurance. And that led the court to think, maybe you shouldn't have the right now to just make a fuss about it, because you have got your contractual provision in place, so that should be given effect to. So convoy time clauses, they will be given effect to, but the crucial thing here is they will not be interpreted in isolation from the remainder of the charter party. So you can't just rely on your convoy time clause and say, I always will have this unrestricted discretion to refuse to comply with charter's orders. The court will not read it, the convoy time clause, in isolation from the remainder of the time charter provisions. So what all these contracts, what all these cases do tell us, that courts will always look into not just one thing, but the contract as a whole. And the crucial thing always for the court is to find out, ascertain objectively the party's intention about risk allocation. And that is a crucial thing. And we can see this repeated pattern in these judgments. So what the parties intended about risk allocation is the crucial matter for the courts. And that's what obviously they're trying to ascertain with all these exercises with contract interpretation. Now, other important, I only have 3 minutes, so I shall be very, very quick now. Okay, so what if you don't have convoy time in a time charter situation? Does that mean that the owner can now and should go wherever the charter wants the vessel to go, including all these dangerous zones that we have got, let's say the Strait of Hormuz? Well, each situation should be assessed on the facts, but the crucial thing is, just because you don't have convoy time form doesn't mean that you now have got no discretion, no power to say no to a charterer. Because we know from English cases, there is this traditional dividing line between employment orders and navigational orders. So if you think that the charter's order is going to put the vessel at risk, you have the discretion to say, no, I'm not going. But the crucial thing is, if you have a provision in place, that obviously puts you in peace, because you'll then be in a position to effectively rely on it. Because what obviously may well happen in a situation is, if you don't have a convoy time form, there could be some arguments about assumption of risk, whether the parties actually knew this, whether the owner actually assumed the risk of going there at the time the parties entered the contract. So it's always good to have convoy time clause in place. But just because it is not in your time charter party doesn't necessarily mean that you have now no right to refuse to complete. The charter's order is likely to pose risk to the vessel, likely to put the vessel at risk. You have the obligation as an owner, apparently, to say no to the charterer, because if you don't say that, and if you just let the vessel go to somewhere that is, apparently dangerous, putting the vessel in immediate danger, that will break the chain of causation, and you will then no longer be in a position to get any indemnity from the charterers in the first place. So those are obviously the important things. Void charter scenarios. So we also have a war clause, BIMCO war clause for void charter parties. It obviously comes up. So if, for example, risk is identified prior to loading, the owner may well cancel the voyage if no alternative port is nominated. So if you go through that, you will also see quite useful set of rules there in place. Obviously, that has to be part of your contract. It's not possible for these things to be applicable to your contract if you haven't incorporated them in the first place. So central to all these things, the master's assessment, risk assessment, must be made in good faith. It has to be objectively reasonable. And you're not looking at theoretical risk here, but real likelihood or serious possibility of exposure to war risk, which does obviously exist in the situation. So it should therefore be possible in most cases for masters and owners to refuse to comply with charter's orders. And one last thing, because I don't have time now, so just to wrap it up. So what if you have got delays? Well, obviously you have got now many vessels that are delayed, they're lying idle. What's going to happen if you are in the course of your time charter? Well, whether the vessel is going to be treated as off-hire. The quick answer to that is if you just have got your basic NYPE, the answer is no. Much will obviously turn on your off-hire clause, how that is worded. Just because you have whatsoever may not also necessarily save you. Again, you need to look at your fire clause in its entirety to make an informed decision on that. So that's what I'm going to say. And if you are in a time void charter, obviously the main regime is lay time and demurrage. If lay time has already started, and if your vessel is waiting idle, well, obviously demurrage will run against the time chart against the void charterer. How far it can go, as far as it can frustrate the contract, as we can say, but obviously that is another risk for parties. So all these things that we see are actually all about risk allocation, and there are various aspects to these things. As you can see, the significant delay that's happening in this trade is obviously causing a lot of legal problems to parties, and all really boils down to risk allocation. The doctrines, even those I mentioned, they clearly say that no court, no arbitrator is going to rebalance parties' commercial bargain, and much of those issues will have to be resolved with reference to the contracts that the parties have. So thank you so much for your time. So that's it from me.
Thank you very much for your explanation. I think it is very interesting to observe, but allow me a little bit to do a backward here, like a small introduction, because I was supposed to do that, but I don't want to put you on hold earlier. So just for information for the audience, that Dr. Melis Osdell is actually the head of maritime law at UCL London. Thank you very much once again. And you have, I know you have a extensive experience because before you're also the director, right, of the UCL Center for Commercial Law, and you specialize in international trade law, carriage of goods by sea, international commercial arbitration, and also conflict of laws and jurisdiction. So very, very good expertise over there. You talk quite extensively about this. I really appreciate. If I may, a little bit, summarizing this. So I understand that you mentioned earlier, although newer BIMCO war risk clauses provide clearer guidance, basically, but the core purpose remain unchanged, right? That's how we understand. And also you mentioned about the possibility to apply doctrine of restoration and so on and so forth. I think we will come back to talk about this. Now I would like to invite our second speaker, but allow me to introduce our second speaker first. Mbak Tiana, full name is Tiana Sigi Pertiwi. You are a lawyer. If I may say a little bit more about you, is a knowledge lawyer at Anggreni and Partners, right? That's the term that we use. Focusing on the ocean, maritime, climate, and trade practice group. So you hold a Bachelor of Laws from the University of Indonesia and LLM from Maritime Law from the University of Southampton. So Ibu Tiana, now the floor is yours.
Thank you, Dr. Andi, for the kind introduction. Good afternoon, ladies and gentlemen, or good morning from wherever you are. As mentioned earlier today, Ibu Setiawati Fitri Anggreni, our managing partner at Anggreni and Partners, and our second speaker today is still recovering her health from temporary inflammation of her vocal cords She is present here today among the panelists. Hello, Ibu Fitri. But to ensure smooth delivery of the second session, I will be assisting her by helping to present the following materials on her behalf. We would also like to say that our team at Anggarani and Partners Law Firm, in support of Ibu Fitri, will also be pleased to discuss with you further on this topic in writing or arrange a separate appointment at a later date as well, if you prefer. We will share our contact email details later at the end of the session for your use. As today we are pleased to speak to you on a subject that sits at a very specific and, as I would argue, increasingly important at this time. Following Dr. Osdale's insightful session, we will be focusing on another aspect, which is the carriage of passengers aspect. Before we further proceed, allow us to firstly clarify the scope of Ibu Fitri's presentation today. This discussion is strictly limited to the issue of personal injury and death of cruise ship passengers in a war risk area. So we are not here to address any subjects or topics related to the political aspects of war or acts of terror. Our lens today is entirely a legal one, although hypothetical, since to our knowledge there is no direct case precedent specifically on this topic yet. So we will examine the current international frameworks governing the limitation of liability for maritime claims and compensation for possible deaths or injury during carriage of passengers, when things could possibly go terribly wrong in some of the world's most dangerous waters prone to war risks. With this important framing established, let us begin. Slide. So first of all, we would like to open this session with some practical questions. You may see at this slide, these are real captions of news headlines from the past few months. Some passengers of some number of cruise ships, including MSC Arabia here, were stranded in Dubai amid the Middle East conflict, as you may know. Recently, it was also reported that at least 6 passenger cruise ships were reportedly stuck in the Persian Gulf. News outlets such as the Straits Times here reported that the Middle East war trapped over 15,000 cruise passengers in the Gulf. Now, we would like to ask you these questions. What will you do if you were a passenger of one of these cruises? Or alternatively, what will you do if you were a ship owner or operator of that same vessel? These are questions that your clients may ask, the courts will have to answer, and then the international conventions we will discuss today were designed with varying degrees of success to resolve. This raises immediate concerns such as what happens if passengers are injured or if there is a loss of life in that war risk area, who will be liable? And more importantly, how much compensation is actually available? This tension between the passenger who has suffered harm and the operator who seeks to limit their exposure is what drives the entire legal architecture that we are about to examine. Next slide, please. Today's discussion is structured across 5 sections. We started already with the opening scenario just now. Then we will move to the section 2, which is the LMNC, covering both the 1976 convention and its protocol. And section 3 will address the Athens Convention and its 2002 protocol, which governs passenger carriage specifically. Section 4, we will examine a case example. Section 5, a comparative analysis of the regime differences between the LMC and Athens Convention. And we will conclude with some brief key insights for your reference. Let us proceed to the next slide. The Convention on Limitation of Liability for Maritime Claims, or LLMC, is a foundational global instrument governing the right of ship owners to cap their liability for maritime claims. So understanding this, who can invoke this right, what claims it covers, and how limitation fund works is quite essential before we can compare it to the Athens Convention. So let's start with the first article of the LMC, the right of limitation and who holds it. The LMC provides that the ship owners and sellers may limit their liability in accordance with the rules of these conventions for the claims set out in Article 2, which we will examine later further. The term ship owner here is defined broadly. So it shall mean the owner, charterer, manager, operator of a seagoing ship, and this is quite an important point of scope since charters and managers are not excluded. Salvage shall mean any person rendering services in direct connection with salvage operations. And crucially, if any claims set out in the Article 2 are made against any person for whose act, neglect, or default the ship owner or salvor is responsible, such person shall be entitled to avail himself of the limitation of liability provided in this convention. In other words, the protection extends downward through the chain of responsibility. The convention also makes clear that the liability of ship owner shall include liability in an action brought against the vessel herself. And for all purposes, an insurer of liability for claims subject to limitation in accordance with the rules of the convention shall be entitled to the benefits. One final note on the first article, which we think is quite worth to emphasize, is that the act of invoking limitation of liability shall not constitute an admission of liability. Next slide, please. Now, how does the limitation mechanism actually work in practice? Under Article 11, any person alleged to be liable may constitute a fund with the court in sum of amounts set out in Article 6 and 7, together with interest from the date of the occurrence giving rise to the liability until the date of the constitution of the fund. Any fund thus constituted shall be available only for the payment of claims in respect of which limitation of liability can be inferred. The fund may be constituted either by depositing sum or by producing a guarantee acceptable under the legislation of the relevant state. Importantly, a fund constituted by one of the persons mentioned in Article 9 or his insurer shall be deemed constituted by all persons mentioned in the corresponding paragraphs. So the establishment of a single fund has a collective protective effect for the group. This mechanism, the limitation fund, is the engine of the LMCA system. It is both the ceiling and the remedy. But what claims are actually subject to that ceiling? Next slide, please. There seems to be a technical error, so let's just wait for a bit.
It's on now.
Slide 7, please. All right, so the following Article 2 sets out the scope. The following claims, whatever the basis of liability may be, shall be subject to limitation of liability. This includes, among others included, as we underscore here, is claims in respect of loss of life or personal injury occurring on board or in direct connection of the operation of the ship. It does not seem to be showing in my... All right. So which is the main subject of our discussion? As shown here, the claims set out in paragraph 1 of this article shall be subject to limitation of liability, even if brought by way of recourse for indemnity under a contract or otherwise. And we come to a specific limit for passenger claims, which is the provision mostly directly relevant to our topic today. Under the LLMC 1976, in respect of claims arising on any distinct occasion for the loss of life or personal injury to passengers of the ship, limit of liability of the ship owner thereof shall be an amount of 46,666 units of account, multiplied by the number of passengers which the ship is authorized to carry according to the certificate, but not exceeding 25 million units of account. So for the purpose of the article, claims for loss of life or personal injury to passengers of a ship shall mean any such claims brought by or on behalf of the person carried in that ship under a contract of passenger carriage, or who with the consent of the carrier is accompanying a vehicle or live animals, which is covered by the contract of carriage of goods. You will also note on the left side of the screen the general limits of under Article 6 applies to all other claims calculated on a per tonnage basis. Meanwhile, the Article 7 is a lex specialis for passengers carved out from that general system. Next slide, please. Yes, so you may note two important changes from the 1976 original made by the protocol. First of all, the per passenger figure has been raised substantially from 46,666 to 175,000 units of account. Second, and critically, the 25 million units of account aggregate cap has been removed. So there is no longer a ceiling on the total fund of the passenger claims. It scales with the number of passengers carried. This shift reflects the international community's recognition that the original 1976 limits were wholly inadequate for modern large-scale passenger vessels. Next slide, please. So as we can see here, the slide brings the number to life in a more concrete way. So let us walk you through the table. First of all, we are looking at a comparison of 4 example vessels of very different sizes, from the Allure of the Sea as the largest, with at 225,282 GT with 6,000 licensed passengers. And then the Queen Mary, the Orion, and down to the smallest in this table, which is the SV Sea Spray. She is at 295 tons with 52 passengers. So we will be tracking the applicable limitation quantum across 4 regimes. Under the LMC 1957-1979, the Allure of the Seas would yield a limit of approximately 46.5 million SDRs for a single incident. Under the LLMC 1976 at 46,666 SDR per passenger, the theoretical figure would be nearly 294 million SDRs, but then the cap kicks in. It is capped at less than 1/10 of that, which is 25 million SDRs. And under the LMC 1996, with the cap removed and the rate rise to 175,000 SDRs per passenger, the figure for Allure of the Seas rises to over 1.1 billion SDRs, no cap, and then the figure is unchanged by the 2015 tacit acceptance procedure, which left the passenger limits untouched. So the data here illustrates starkly why the 1996 protocol mattered so profoundly. Next, please. And now we will turn to the Athens Convention 1974 and its 2002 protocol. So if earlier the LMC is the ship owner's tool, then the Athens Convention is the passenger's instrument. So where the LMC asks how much can the ship owner cap, then the Athens Convention would ask what is the passenger guaranteed. By the time of the adoption of the Athens Convention, there are 25 states became party to it, and it rests on 4 key pillars, as seen here. First is the international carriage. The convention applies where the ship is flying the flag of or registered in a state party to the convention, or the contract carriage has been made in the state party, or the place of departure or destination according to the contract of carriage is in a state party to this convention. Second, fault-based liability. The carrier shall be liable for the damage suffered as a result of the death or personal injury to a passenger due to the fault or neglect of the carrier or of his servants or agents acting within the scope of their employment. The burden of proof shall be with the claimant. Third, limitation of liability. The liability of the carrier for the death or personal injury to a passenger shall in no case exceed 700,000 francs per carriage. Fourth, the time bar. The limitation period is 2 years from the date of disembarkation of the passenger, but in case of death occurring during carriage, it is from the date when the passenger should have disembarked. if it is in the case of personal injury occurring during carriage and resulting in the death of passenger. After disembarkation, it is from the date of death, but shall not exceed 3 years from the date of disembarkation. And next, the 2002 protocol modernized the Athens Convention. Today, there are 34 states party to it, and it introduced 5 key changes. First, the strict liability for shipping incidents. The carrier shall be liable to the extent that such loss in respect of that passenger of each distinct occasion does not exceed 250,000 units of account, unless the carrier proves that the incident occurred not through fault or neglect of the carrier, or that it was act of war. The second feature is the precise definition of shipping incident, meaning shipwreck, capsizing, collision, or stranding of the ship, explosion, or fire in the ship, or defect in the ship. And defect of the ship means any malfunction, failure, or non-compliance with the applicable safety regulations. Third, the higher limitation, the liability of the carrier for death or personal injury to passengers shall in no case exceed 400,000 units of account per passenger on each distinct occasion due to the fault or neglect of the carrier or his servants or agents acting within the scope of their employment. Fourth, direct action against the insurer. Any claim for compensation covered by insurance or any financial or security pursuant to this article may be brought directly against the insurer or any other person providing financial security. Fifth, compulsory insurance. Carriers are now required to hold a certificate of insurance or any other financial security in respect to the liability of death and personal injury of passengers. Next slide, please. Now we turn from the legal framework to real life application. Although this is not a direct case example of how the Athens Convention or LLMC applies to passenger injury or death in war or terrorism context, but the Costa Concordia disaster we would examine here is arguably the most important mass passenger casualty event in the modern maritime history from a liability standpoint, and it continues to shape the discussion of limitation frameworks to this day. So as you may know, the Costa Concordia disaster occurred back in 2012 when the Italian cruise ship ran aground and capsized off the coast of Tuscany, Italy. The incident was attributed to the captain's deviation from the planned route. It resulted in deaths of 32 people, evacuation of over 4,000 passengers and crew, and the captain was charged with manslaughter, sentenced to 16 years in prison for sailing off course and abandoning the ship prematurely in violation of his duty to oversee orderly evacuation and ensure passenger safety. This case is a leading example of mass passenger casualty, is illustrating the operation and the limits of international liability and compensation frameworks. The carrier was largely subject to the Athens Convention, which presumes fault in cases of shipwreck, limiting liability for passenger death or injury to a specific amount, roughly 46,666 SDR at the time. In the context of LMC, it is a system limiting liability for the loss of life or personal injury, unless it is proven that the loss resulted from the ship owner's personal act or omission committed with the intent or recklessness. The incident prompted expanded discussion on the establishment and sufficiency of the limitation funds at that time. The actions of the captain, deemed as gross negligence, were central to challenging these liability caps. And following the case, the 2002 protocol to the Athens Convention raised these liability limits and introduced mandatory insurance, significantly increasing protection for future passengers, as we briefly touched in slides prior. Now we bring together the two frameworks we have examined and compare them directly. Next slide, please. So let me briefly walk you through the key figures side by side, so the relationship between these frameworks is more clearer on one screen. Under the LMC 1976, 46,666 units of account multiplied by the number of passengers which this ship is authorized to carry according to their certificate, but not exceeding 25 million units of account. Under the LMC 1996 protocol, it is 175,000 units of account multiplied by the number of passengers which the ship is authorized to carry according to the ship's certificate, with no aggregate cap. Under the Athens Convention 1974, the liability of the carrier for the death or personal injury to a passenger shall, in no case, exceed 700,000 francs per carriage. And under the Athens 2002 protocol, the loss suffered as a result of a death or personal injury to a passenger caused by a shipping incident, the carrier shall be limited to the extent that such loss in respect of that passenger on each distinct occasion does not exceed 250,000 units of account, unless the carrier proves that the incident occurred without fault or neglect or was an act of war. So these figures could tell you the story of a gradual but decisive evolution from low capped limits towards high uncapped passenger protective regimes. Now, our discussion today highlights three key differences. First, the LMC is the ship owner's global limitation regime. The primary focus of protection is preventing the financial ruin of the ship owner by limiting the ceiling of liabilities for certain claims. Second, the Athens Convention is the passenger's protection regime. The primary focus is for passengers by providing direct compensation for death or personal injury due to shipping incidents. It is the instruments that basically answer the question, what am I entitled to if I am harmed during this carriage? And third, connecting the two, compulsory insurance and global limitation fund question. The Athens Convention requires ship owners to provide compulsory insurance by enabling direct individual action by passengers. The LMC, by contrast, requires a legal action by the ship owner to constitute a fund and stay on proceedings. The Athens Convention is, in this sense, more passenger-friendly procedurally. The LMC mechanism, while comprehensive in scope, requires the ship owner to take active steps before claimants can be paid from the fund. Let me close with some very brief practical takeaways and insights addressed separately to the groups which we had in our opening question, which is the passengers and ship owners. So for passengers, they should assure before booking or embarking in a cruise ship if their cruise operators can demonstrate valid liability insurance and, where relevant, a blue card covering passenger injury or death under the Athens Convention, especially for voyages into war risk areas or terrorism-prone zones where standard liability policies often exclude such perils unless specifically written back. Tickets are not evidence of insurance, and only the actual insurance contract determines coverage. If the operator of such cruise lack proper cover, the passenger may need to pursue claims based on the contract of carriage and seek compensation in the most favorable jurisdiction permitted by the contract and other applicable conventions. And of course, for ship owners and operators, some of our key insights are you need to anticipate war and terror risk when heading to high-risk areas. Acquire appropriate war risk extensions or separate war risk blue card cover for passenger liability, and critically, regulatory authorities and port states may also deny access if the ship owner cannot provide evidence of insurance or financial security covering anticipated liabilities. And then overarching both groups, two major principles that we would like to ask you to take away from today's presentation is that, first of all, the existing of compulsory insurance and limitation funds is central to ensuring compensation for passengers, and war or terror is not a blanket defense for liability for passenger injury or death. That means mandatory convention protections shall prevail over contractual exclusions, if applicable, unless the carrier proves intent or recklessness. And as such, that concludes our presentation today on the limitation of liability for maritime claims and compensation for carriage of passengers in war risk areas, which we focused earlier on passenger personal injury and death. This is presented on behalf of Ibu Fitri, our managing partner at Anglo-Indian Partners. We hope that this has provided a brief intro and perhaps hopefully a useful map for you on the two primary international frameworks, the LMC and the Athens Convention, on how they interact, how they have evolved, and what it means in practice for both passengers and operators internationally navigating war risk waters. And also to close our second session today, 15 April 2026, as a matter of fact, by the early hours today, 114 years ago, was the exact time when the infamous Titanic sunk. So we would like to emphasize that the safety of passengers should be treated as a priority and paramount. We are happy to arrange a private discussion with you separately at your convenience, either in writing via email or in form of an introductory call or meeting in either our head office located in Jakarta, Indonesia, or in Malmö, Sweden. Please do not hesitate to contact us, discuss directly with Ibu Fitri or us, the team of lawyers and researchers at the Ocean Maritime Law Sector Focus in Anglo-Indian Partners Law Firm. Please do contact us through the email present on the screen. Thank you.
Thank you very much. Very good use of timing also. I really appreciate that. Thank you, Ibu Tiana. Once again, you reminded us that in war risk areas, liability is not only about contracts, but also about protection and compensation, right? That's how I try to understand this. So you also clearly distinguish between the LLMC regime, which focuses more on limiting ship owners' overall exposure, from the Athens Convention also, which is designed to, if I understand this correctly, protect passengers through direct compensation, right? Now I would like to open the floor for discussion. We actually already have one question directed to Dr. Melis Ozdel, if I may read it for you, Melis. This question is from Adam Suharto. The question is like this: how does the doctrine of causa proxima or proximate cause operate in the event of cyber attack and so on and so forth? I think you can also read it, right?
I don't think I can.
You can, okay, right. Let me just read it for you.
Okay. So
operate in the event of cyber attack that disables a vessel's navigation system which within a conflict zone. So would such a loss be classified under perils of the sea, standard marine insurance, or war terrorism risk?
Okay, so I have now seen it. So
yes, okay,
okay,
yes.
so right. Oh, okay, right. Okay, so the crucial thing obviously
Please.
here is to just bear in mind, we don't obviously expect just one cause leading to whatever damage it may well cause to the vessel, right? So obviously, doctrine of proximate cause, as it was put in the question, it will depend obviously on the situation here. So what I would say, if a vessel's navigation system within a conflict zone, the course will usually look at, so there are a number of things. So whether there is the effective cause or the dominant cause. So you may need to look into the situation because it depends on the question that's being asked. So for example, if you have got a case indemnity in the context of a time charter, the test there is not proximate, but the effective cause. In many seaworthiness cases where it is combined with dangerous cargo, etc., again, the question was based on not the proximate cause, but the effective cause. So the crucial thing obviously here is, first you need to identify in what context you ask the question, because proximate cause is not, it's something that is mainly discussed in the context of insurance, but in the context of carriage of goods by sea, we increasingly see reference to effective cause than the proximate cause. And an effective cause is the operating cause. It doesn't have to be the dominant cause, if that makes any sense. So that is why you need to look at it in that context, and how the insurance so how the war risk clauses were interpreted, how the damages clauses, if there are any damages clauses, are in there. So you need to therefore look at the contract as a whole to find out. But mainly where you have got more than one cause leading to the loss, you need to first find out in what context you're asking, in what context you'll be determining the liability issues. And depending on that context, yes, but for test is not relevant, because we do tend to see usually one cause leading to the loss. And we therefore need to then ask ourselves the question of, are we looking for something dominant, or would just effective cause be sufficient? And in the context I have mentioned, sometimes just effective cause can actually do the job. And so as long as it's something that is the operating cause, then it might well be possible for you to rely on whatever you want to rely on. So that is how I would say there's nothing of it. So let me just see. So cyber criminality and state-sponsored aggression. I'm not quite sure what is meant by that. So cyber criminality and state-sponsored aggression, I'm not sure. So I need more clarification on that. And what I can say is, and there's no one single test of causation. So you need to look into in what context you're asking that question. Because the legal question do change, and we don't necessarily look for approximate. Sometimes effective cause can actually do the job. And what causation is going to apply, and what context you're looking at, you need to look at the contract as well. So cybersecurity, that matters sometimes, is regulated. Fact. So you need to look into the contract in place to find out how you're going to fit that within the whole liability spectrum. So that is also quite important. It's an interesting question. So thanks for that.
Thank you, Melis. If I may add a little bit, based on my understanding, in general, this is how I understand this. We have event, and that event can be categorized into one or two. So now we understand that the borders between these different categories are getting thinner or even blurred. Do you agree with that, Melis?
In what context? I mean, it does blur. I mean, causation is always a problematic area of law. We have had situations, I mean, especially if you just move into tort law, then the causation issue gets even worse. Now, our understanding, and I think I should also mention, so English contract law is not based on fault. So you don't breach it. So we never actually look into anyone's mindset or whether they were actually faulty in the civil law sense. That's not what we do. They have an obligation. If that is not complied with, whatever, then they are in breach. So normally most of the causal issues and contributory negligence kind of stuff, we are able to just put that aside most of the cases. But sometimes obviously it's not possible, and especially in carriage cases as well, where you have more than one cause is leading to the loss, then you come up with no. If I may just give you an example in the carriage context, because it's quite relevant to what I have discussed. Probably many of you would know indemnity. So time context, there is the implied indemnity obligation by the owners in relation to losses arising from their instructions. So very relevant to what we have got at the moment, right? So maybe the owner may need to pay a really large fee, let's say, to an authority so that the vessel can safely pass through the corridor. Let's say 2 million they're speaking of, right? So can that sum, for example, be recovered from the charterers? But the crucial question is, well, you may not always be in a position to have this direct causal link between the loss and the charter's instructions. A lot comes into play, right? So you give the instruction to the master. Now the master is in charge. Whether he's actually should be expected to comply with it, how he's going to react to, let's say, imminent danger that's happening there, the contribution of third parties involved, in situations like this, right? So in many cases, the courts had no option but to say, we're not looking at the immediate cause of the loss. We need to go beyond that and ask ourselves the question. We're not going to go with but for. We're not going to look at immediate cause. We need to look beyond that and say which one is the operational one, which one is the effective one. So causation is a difficult area. The thing, obviously, in practice, in legal practice, that's what we know. So it's a factual matter. So it will be obviously up to the arbitral tribunal or the first court to decide about the questions of fact. But it's really a fact-driven analysis. And what we can just get from the cases is but that is because of the nature of causation, isn't it? It's just the way it is. So you can't have a hard and fast answer to these questions in a way.
Right. Thank you so much. I would like to remind participants to ask questions through the Q&A facilities that we have in our Zoom. Now, the second question, I think this is from Dr. Fatih Cemal Karaitu. This is for Ibu Tiana. Yeah? So, two questions actually. One of doctrine view on the relationship between LMMC and other convention is a matter of priority. That's the understanding. It is said that LMC is, in general, a general framework of vessel ship owners' sole liability, which arise by other convention, cannot exceed the limits in the LMC. So do you have any comment on this? That is one. And the second will be actually not part of the presentation, actually, this question, but related with the presentation topic. How do you interpret Article 4 of LLMC in Indonesian maritime law? Tiana.
All right, thank you for the question. Regarding LMC, it is correct that this is a general limitation regime, but saying that it always has a priority over the other conventions is, I'd say that it is too absolute. So, first of all, I would like to put out there that for Indonesian context, since you've asked in your second question about the application to Indonesian maritime law. So LMC and Indonesia is not party to both of these conventions, the Athens Convention and LMC expressly. So maybe first of all, you would ask, like, if these two conventions were not ratified or applicable in Indonesia, then why are we discussing such matters? So first of all, Indonesian ship owners who are operating internationally, particularly who those ships call at ports of LMC state parties, they should be aware that they may be subject to the convention if the trigger applies, in which if it's applied by the flag state or port state of the incident, not Indonesian law. And for Indonesian passengers, if they travel on a foreign flagged vessel, and an incident occurs in a state party in which they are a member of the conventions, then foreign courts or those jurisdiction may apply if they are state party to LMC, and the limits to their claim would also be applicable. And the Indonesians' non-party status does not protect Indonesian passengers from having their recoverable compensation capped by another state's application of the LMC. As for the question earlier, sorry, where is it?
Can you see that?
Yeah, the first. Cannot exceed limits of the LMC. Yeah. So it's not just the LMC, but the Athens Convention as well. So it does not mean that one convention applies and then the other does not. So it could apply both of them. It's a separate regime, and each convention has its own trigger rules. But their special conventions are often override or bypassed by the RMC. And if for Indonesia, since we have not ratified both conventions, so if the incident occurs in Indonesian waters, then that means that the domestic law applies. And I hope that answers your question.
Okay. All right. Thank you so much. Dr. Osdell, do you have any?
May I read it out for us? I think that I got one question here. So it reads, in a case where a vessel becomes disabled during transit, the cargo remains intact. Should this be treated as a foreseeable contractual risk that all expressly indicate it? So are there beam clause or stamp provisions that are useful to include in future contracts? It's a very good question. It's just it has got a lot of components. So first, let's start with the first one. So if a vessel becomes disabled during its transit, but the cargo remains intact, should this be foreseeable? So we obviously need to know why the vessel, if we are thinking of the current.
I think connection problems, right? Dr. Osdell is no longer with us, correct?
Yes, same with us.
Right. Okay.
She's back.
Well, okay. He's back. She's back.
My apologies. My
No
apologies.
problem. Please continue.
Let's carry on. So we obviously need to know why the vessel became disabled. So the cause of that is going to obviously give us whether this is a foreseeable event or not a foreseeable event. So the causal connection is quite important there. Assuming this is, the current crisis that we have. Again, whether it is a foreseeable contractual risk or not will depend. Because the crucial thing here is foreseeability is assessed at the time of contract conclusion. Everybody now knows whatever happens there, it's a foreseeable event. So if you send your vessel there around that region, it will get stuck if not damaged. We know that. But when assessing foreseeability for the purposes of allocation of risk in charter parties, in sale contracts, we basically look at whether this was foreseeable at the time of contract conclusion. There are so many cases, English cases, where they actually guide us through this and say, on the issue of foreseeability, you need to look at the time when the parties conclude the contract, and not afterwards. So that is the first thing. The second thing is that ought to be expressly allocated. So foreseeable contractual risks, as I said earlier, it will be ideal if you actually have got something in place in your contract that deals with whatever contingency that you think might occur. I think it definitely puts parties in peace, in their minds in peace, and it will be the best solution forward. Because as I said earlier in my presentation, look at House of Law decision in the NEMA. They clearly say, and I just repeat, unforeseeable events are likely to give rise to frustration, but you may sometimes have cases where you predict a foreseeable event. It may well be, things that happened in the past. Foreseeable events can also sometimes give rise to frustration. Not necessarily. The likelihood there is obviously not as much as what you would have if you have got an unforeseeable event. But at the end of the day, this can't be ruled out. Frustration can't be ruled out just because the event seems to be foreseeable in the future. So the best thing I would recommend is to have some contractual provisions in place, because frustration is also not the best way forward. You may well say, oh, it's fantastic. When the contract is frustrated, I'm discharged of my contract obligations, happy days. Well, not necessarily, because once this happens, you have no control over it. The frustrating event is going to kill your contract. Both parties will automatically discharge from contractual performance. Maybe you had some reimbursement issues, maybe you had some issues there, maybe you just incurred some expenses, assuming that the contract will go on. It's never a good thing to say the contract now is discharged automatically. Parties now have got no control over it. It's better to think of these things ahead. It's better to cover the contingencies that you think are likely to happen. It's better to have those things. And that is why, organizations like BIMCO, they just sit down and do the necessary work to think about all the contingencies so the parties will know where they stand, where uncertainty happens, where things happen, when seemingly unforeseeable things happen. Would I recommend any clauses? That was the final bit of the question. So you have con wartime and war clauses. So the recent versions of those are 2025. I think it will give you a good security in place so that you will know what to do. So, for example, in the question you asked, so what happens? You have a cargo that becomes intact. So you have got, for example, war 2025 void charter scenarios, if we look at it. So it comes up with lots of options. So if before loading, if the place that the vessel was going to proceed becomes dangerous due to a warlike situation, so if the risk is identified prior to loading, the owners can cancel the voyage if alternative nominated. During or void. So this is what obviously being asked for 2025. The owner or the master can suspend operations or proceed to a port of this and entitlement to additional freight where applicable. Alternative routing might be possible if you're not yet trapped, for example. Insurance contributions also are there. Increased voice insurance actually incurred. Secure in claim co-close, as I have mentioned. But again, a word of caution, because of the Supreme Court cases I mentioned, these clauses will not be read in isolation from the other things that you put in your contract. So please make sure you have consistency, and please make sure you don't put anything that's going to undermine or weaken.
Is this gone again? All right. Welcome back.
So final word is, so you must make sure that you don't have anything conflicting or undermining that are given to you under these clauses. So that's the most important thing.
Right. Thank you very much. We still have not that much, like 8 minutes. I still have one question that I made to Ibu Tiana. Is probably a little bit more practical. So in practice, do you think the current liability limits under the LMC and Athens regimes remain adequate for modern cruise incidents involving, for example, thousands of passengers? What do you think about that? Still muted, sorry.
Apologies, Dr. Andy. Can you please
Repeat.
mention
Okay.
your question again?
Sure. So in practice, do you think the current liability limits under the LMC and Athens regimes remain adequate for modern cruise, for example, the one or modern cruise incidents in this case involving, let's say, thousands of passengers? Do you think it's adequate for that?
Right. So I think there may be a gap in both conventions that the presentation does not fully address. So it's important to note that the war risk itself, because we are talking about war risk in this context, it does not clearly defined by the either the LMC or the Athens Convention itself. So in in the light of the events that is currently going on in the Middle East, there also may be a possibility that there will be developments in response to this situation. And also, we were talking about the in personal injury and deaths as well. But if you are asking about as to whether or not compensation is adequately or sufficiently addressed in both conventions, I think there may be a gap in both conventions in some areas that maybe not necessarily mentioned or highlighted in today's presentation. It is the issue of a pure economic loss by the passengers, or repatriation costs, or stranding expenses. Because earlier we did establish that some shipwreck incident, the shipping incidents may not be applicable to what is happening in our real life case, in which that may not be classified as a shipping incident because it's not a shipwreck and so forth, but it's to the fact that the vessel itself is just hindered, or it's obstructed to the fact that they are stuck in the Persian Gulf or in Dubai, and they just simply cannot pass or continue their voyages. So maybe under the LMC Article 2, paragraph 1.b, if I'm not mistaken, the claims for loss resulting from the delay of carriage by sea of passengers are subject to limitation. So a passenger stranded in Dubai, for example, due to the conflict, could in theory claim delay losses within the LMC fund because it's a general limitation, and it's not just purely for personal injury cases, but also for cargo as well. But however, this is likely the quantum may be modest, and it competes with the other priority or hierarchy losses suffered by the passengers, such as the personal injury and deaths obviously would take priority. And then for the Athens Convention, the convention itself does cover death and personal injury and probably luggage loss, which we did not delve in today's presentation, but pure economic loss from stranding, such as probably hotel costs by the passengers who were stranded, missed flights, or probably psychological distress, it kind of, in our opinion, falls into a gray zone. So the Athens Protocol 2002 does not expressly cover this. The passenger would then have to rely on their contract of carriage themselves. And this is why we emphasize to passengers to make sure that your ticket terms and whichever consumer protection law applies according to your jurisdictions applies in the forum state that you are. So the practical answer to this is probably there are some gaps that may need to be discussed further in the future.
Right. Thank you very much. I think we are all enlightened by our two speakers. So on behalf of BIAMC, I would like to thank Dr. Osdel also, Ibu Tiana, and also Ibu Fitri. Certainly, thank you very much. I think also to the audience, of course. So today's discussion has shown that in times of conflict like this, maritime law is not only about managing risk after disruption occurs, but also about allocating responsibility before it does. Whenever through careful contract drafting, just like Dr. Osdel mentioned, also insurance mechanism or liability regime. So preparedness remains the key to resilient in global shipping. So with that, I thank you very much. And now it comes to the end. Thank you very much, everyone. Bye-bye.
Very much. Bye. Thank you.
Thank you very much.
Thank you.
Welcome to the Bali International Arbitration and Mediation Center, or BIAMC, where the serene beauty of Bali meets the precision of international dispute resolution. BIAMC is Indonesia's only international organization devoted to international dispute settlement through arbitration, mediation, and alternative dispute resolution, or ADR, located in the heart of Bali, and one of the premier providers of dispute resolution services in the Asia-Pacific region. As the most populous country of ASEAN, Indonesia is in a prime position, and BIAMC, as a private, neutral, non-profit organization, aims to develop Indonesia's arbitration and mediation capabilities through international cooperation and education. Thus, institution and academy are main pillars of the BIAMC. The BIAMC Institute. It is composed of 3 integral components. These components include the rules and procedure, our cutting-edge facilities, and the distinguished panel. Our vision is to be the world's leading diverse arbitration and alternative dispute resolution platform. We aim to achieve this through an international team and a panel of skilled arbitrators and mediators, well-versed in various legal subject matters. Our central motivation is rooted in the core belief of you first. We commit ourselves to administering a viable collective bargaining system, fostering a client-centered, integrity-infused, and outcome-driven culture. BIAMC facilities boast 4 meeting rooms with different capacities to accommodate various needs. From the intimate Paris room to the spacious Hong Kong room, our setup options ensure a flexible and tailored experience for our clients. Guiding BIAMC with unwavering leadership is Naz Shinder, our esteemed founding chair and CEO, alongside Professor Dr. Ida Bagus Ramadi Supankana, who serves as the chief of the advisory board. The distinguished board of founding members and advisors at BIAMC features an assembly of international luminaries, each bringing a wealth of expertise to our organization. This esteemed group includes Professor Zhao Yun, Professor Peter Malanjuk, Dr. Bambang Supriyanto, Professor Abu Bakar bin Munir, Professor Ida Bagus Wayasaputra, and Ahmad Fahmi Shahab. BIAMC proudly assembles a globally diverse panel of experts in arbitration and mediation, with members from nations worldwide. They are from USA, United Kingdom, Australia, China, Japan, Germany, France, Turkey, Indonesia, Hong Kong, and many more. Our panelists are a distinguished group of professionals, each bringing a unique and valuable perspective. From founding partners and law professors to senior counsels, independent arbitrators, chairpersons, and many more, the panel embodies a rich tapestry of expertise. So whether it's the insight of a founding partner, the wisdom of a law professor, or the guidance of a senior international arbitration advisor, our panelists are at the forefront of their fields, ensuring unparalleled quality and depth in every discussion. Under the Institute, we offer a model clause for arbitration tailored for both future and existing disputes. For future disputes, parties can include a clause in their contract referring to BIAMC for arbitration under the UNCITRAL rules. And for existing disputes, if parties wish to vary a dispute resolution clause to provide for BIAMC arbitration, a recommended clause is available. But BIAMC is more than just resolutions. It's about building bridges and fostering global partnerships. Under our institute, we have signed Memorandums of Understanding, MOUs, and cooperation agreements with esteemed organizations and universities worldwide. Cooperation Agreement, signing with the International Center for Dispute Resolution, Asia Case Management Center, American Arbitration Association, ICDR AAA. Cooperation Agreement signing with Hong Kong, International Arbitration Center, HKIA. MOU, signing with Japan International Dispute Resolution Center, JIDRC. Cooperation Agreement signing with Istanbul Chamber of Commerce Arbitration and Mediation Center, ITOTAM. MOU, signing with Beijing Arbitration Commission, BAC, Beijing International Arbitration Center, BIAC. MOU, signing with Asia International Arbitration Center, AIAC. Cooperation Agreement signing with Beihai. Asia International Arbitration Center, BAIAC. Cooperation Agreement signing with the University of Singapore Bangsa, Kawarang. Agreement signing with Bangladesh International Arbitration Center, BIAC, and many more. As we continue to expand our network, BIAMC remains dedicated to providing unparalleled services and resources to our clients worldwide. Let's delve into the dynamic world of BIAMC Academy, where knowledge, innovation, and development come together to shape the future of alternative dispute resolution. It stands on three strong foundations: membership and certification, online education, and offline education. Our vision is to be a global leader in ADR education, recognized for providing expert training and fostering the development of skilled professionals, contributing to efficient and effective dispute resolution worldwide. Our mission is to empower students, legal practitioners, and professionals to develop the necessary skills, knowledge, and experience for successful careers in the field through comprehensive and practical ADR education. At the BIAMC Academy, we believe in providing a tailored journey for every individual. Let's explore into our diverse membership options designed to cater to varying levels of expertise and experience. Whether you're just starting your journey or bringing a wealth of experience, we have the perfect membership option for you. Start out as a student member, open to anyone currently enrolled at a university during the application process to embark on your ADR adventure. General membership is another excellent option, also open to anyone with an interest in alternative dispute resolution from the age of 18. Elevate your ADR journey with BIAMC's titled memberships. Start as an associate with ABIM Postnominals, showcasing your aspiration. Progress to fellow, boasting FBIM for instant ADR community recognition. Reach the pinnacle as a senior fellow, using SFBM to be instantly acknowledged as the ultimate expert. Showcase your ADR excellence. Explore our exclusive corporate membership, offering customized dispute avoidance and resolution training for your entire corporation. Receive industry-specific advice tailored to your needs. Additionally, our professional services firm's membership provides a unique platform for marketing your services to BIAMC members, Indonesia, and the broader Asia-Pacific region. Our members are situated worldwide, with a presence extending from the USA to Australia, reflecting the global reach of the BIAMC community. In the midst of an exciting learning journey, our extensive selection of courses awaits, available both online and offline. Discover various interesting topics designed to give you essential skills for success in international dispute resolution. Check out online courses like Introduction to Alternative Dispute Resolution and Drafting VCs in the Legal Industry. And our offline or in-person course, you can meet experts in person through programs like the Essentials of International Investment Law and Arbitration and International Arbitration Certification. We've collaborated with organizations like ILM's and Schindler Law Firm, offering webinars live-streamed through BIAMC's YouTube channel. Notable collaborations, such as the special training with TEAC and USAID, demonstrate our commitment to tailored education. What sets BIAMC Academy apart is our roster of facilitators. They are accomplished experts worldwide in the field of ADR. Each course is taught by seasoned practitioners who are professionals with a proven track record, individuals who have successfully mediated, arbitrated, and negotiated a wide array of disputes. BIAMC takes great pride in its robust backing from a global network of international arbitration centers, universities, and organizations, providing unwavering support for all of its events. Captured in our photo gallery, showcase the vibrant spectrum of BIAMC's commitment to collaboration, knowledge, and innovation. Experience the grandeur of the Arbitration Summit, where global luminaries converge for insightful discussions. Feel the pulse of live-action simulations, where real-world scenarios unfold, providing an interactive and engaging learning experience. Our courses and events offer more than just discussions. They provide an interactive and engaging learning experience. Thank you for exploring the dynamic world of Bali International Arbitration and Mediation Center with us. Should you have any questions or would like to reach us, please feel free to email us at info@baliarbitration.org.
Bali International Arbitration and Mediation Center. Introduction to BMC Membership.
ADR and arbitration can boost your career in law, but finding quality education can be pretty tough. Instead of spending thousands of dollars on individual courses, we suggest getting an annual membership to the BMC. It's the new, affordable, and easy solution, packed with career-boosting benefits. In this short video, you'll discover the best BMC membership to help you reach your goals. So, which membership option is right for you? All our memberships include on-demand access to our online ADR and arbitration training, and the opportunity to engage with our amazing community of leaders, executives, and professionals in the ADR field. If you're not already a member, you'll need to start out with an individual membership. Simply choose between a student or general membership to get started. If you want to enhance the ADR and arbitration knowledge in your organization, or promote your professional legal services on our platform, then a corporate membership is the one for you. If you already have experience in the field of ADR, you'll be looking for a titled membership. Get a prestigious Associates, Fellows, and Senior Fellows membership to showcase your talent and experience. Become a member today and experience the benefits one affordable membership can bring to you